Everyone. So firstly, well done for coming to a presentation about data protection on a Thursday lunchtime. So bravo for that. In terms of what we're going to cover, we're going to sort of take a fairly high-level approach, running through sort of the key things that you need to think about. So the thing about data protection is it is a little bit technical, so we're trying to keep that nice and simple and sort of run through themes more than detail. And then we'll finish up having a bit of a think about the sort of key things that you need to be doing. Before we start, though, a little bit about us. So I set up the firm sort of 13, 14 years ago. I used to work on what I loosely call the dark side of law, so sort of doing $500 million plus M&A, so basically buying and selling listed companies. I set up this firm, as I say, sort of 13, 14 years ago. And ever since then, we've worked exclusively with startups. For us, startups is a relatively loose term. So it's everything from sort of pre-incorporation, so working with founders, all the way through to exit. In terms of exit values, most of our clients get sold by about 250 million. A lot of money and a good chunk of change if you can get it, but actually in the grand scheme of things, viewed as sort of relatively small. So we sort of do those, well, big, but theoretically sort of relatively smaller sort of startups. Most of our clients, probably sort of 75% are in a tech space, lots of different variants of tech. Obviously, at the moment, lots of AI stuff. And then we have an interesting mix on the other 30% of sort of restaurants and hospitality, a good chunk, and then bits and bobs of other stuff as well. So in terms of what we're going to talk about, we're going to start with the basics. So what's personal data? What are the lawful processing requirements? And what documentation do you need? We're then going to have a little bit of a think about sort of two specifics. So what do you need to do when you transfer personal data out to the UK, and what are the rights of data subjects? We'll have a little bit of a think about where the law comes from, because it isn't, unfortunately, as straightforward as it just being UK law. And then we'll finish off with two little bits of thinking. So 5 steps to compliance, and then thinking about how you can turn what at first looks like a problem into an opportunity. So in terms of what we mean by personal data, what we are talking about is data that identifies an individual. So it's things like name, address, contact details, and those other things you can see on the screen. It doesn't include business data. And what we mean by business data is, you know, sort of business name, business address, business email address. But just to be clear, if you have the email address of somebody who's acting in the course of business, and it identifies them as an individual, that is personal data. So really you're thinking, you know, names, address, email addresses, all that kind of stuff. There's a distinction between what you might call sort of loosely normal personal data and then special category data. And special category data has more onerous obligations attached to it in terms of what you can do, what you can use it for, how long you can keep it for. And that special category data is the sort of second box on the screen. So it's information that relates to race, ethnic origins, religious and philosophical beliefs, genetic data, biometric data, mental health, sex life, sex orientation, and details of criminal offences. So that stuff is special category. As a rule of thumb, you don't want to be collecting special category data unless you absolutely you need it. So way back when, sort of, I don't know, 5, 10 years ago, a lot of what we used to call big data businesses, their approach would be, let's get as much data as we can possibly get, because we figure that it may be useful to us at some point in the future. And so you had bizarre circumstances where, you know, businesses that were, you know, social media platforms, they were collecting information about sexual orientation, they were collecting information about you know, sort of mental health and disability when they absolutely didn't need it. And the idea was, well, maybe it'll be useful in the future, maybe we can monetize it. That is absolutely not acceptable now. So you have an obligation to minimize the data that you collect and only collect what you absolutely need for the goods or services that you're providing. And in terms of special category data, that is even more the case. So you shouldn't be collecting special category data unless you absolutely need it. In order to process personal data in a lawful manner, you need to follow the 6 principles and have one or more valid processing conditions. So the 6 principles are basically the guiding principles of data protection law. So you have to make sure that the way that you process data is lawful, fair, and transparent. So in other words, you're explaining to people what you're going to do with their data and why you're collecting it. You have to have specified, explicit, and legitimate purpose. So if you're going to collect a specific bit of data, so let's say, for example, you're going to collect somebody's email address, you need to be telling them why you're collecting it and what you're going to do with it. So if, for example, you say, we're going to collect your data, your email address, in order to create a profile for you on our platform, and in order to send you, I don't know, order updates, what you can't then do is you can't then take that email address and start using it for marketing purposes or sell that email address to marketing companies. So you have to be clear about what you're using data for. Your processing of data has to be adequate, relevant, and limited. In other words, you only process data as you need to do it for your business. You don't process data for the fun of it and do all sorts of weird and other stuff with it. You need to make sure that the data you have is accurate, and that's an ongoing obligation. So if you collected people's addresses, for example, you need a process to update those and make sure that those addresses are current over time. And different businesses take different approaches with it, but the important point is you do need to make sure data is accurate. You should retain data for no longer than is necessary. So bluntly, most businesses, particularly sort of smaller businesses where data is not the core of their business, basically they keep personal data forever and they don't have a process of deleting it and removing it. You have to have a process of deleting data. So what you should be doing initially when you sort of set up your business and then on an ongoing basis is figuring out how long you need each bit of data for. So it may be that, for example, you need to get certain data to comply with legal obligations. So if you think about law firms, we are required to collect money laundering information, so passports and ID stuff. And we have to hold that for a certain period of time, which is generally about 6 years. So we will keep that data for, say, 6 years. But if you join us as a client and you send us, I don't know, bits of information about your investments that you were making, and you've sent that to us because there's a specific dispute that you have, maybe we don't need to keep that for a long period of time. It may be that we can delete that after a certain period of time. So you need to think about data retention and what your policies would be. And then the final one is you need to store data securely. So obviously, personal data, if taken by the wrong people, can cause lots of harm for them. So, people hack personal data, they create fake profiles, fake IDs, they hack people's bank accounts. So you need to make sure that you keep data securely and that stuff doesn't happen. In terms of the processing conditions, so these are the conditions that apply to every single thing you do with personal data. So if you collect personal data, you need to have a legal reason for doing it. And these are processing conditions. For most businesses, the processing condition that's most relevant is contractual performance. So in other words, we are collecting this data because we need it to provide goods and services to you. Legal obligation is effectively where you have a legal obligation to collect the data. So law firms, we have to collect money laundering information, so ID stuff, to ensure you're not a criminal and to comply with our regulatory obligations. So that's legal obligation. Consent is something that a lot of businesses used to rely on. So pre-GDPR, so the rules that came in 2018, you would often find that businesses in their privacy policies would say, we are collecting your personal data with your consent, and consent is our processing condition. A lot of businesses no longer rely on consent. And the reason is that in order to rely on consent as a processing condition, you need to have an explicit opt-in for every single processing activity on which you're using consent. So let me give an example. Let's say that you collect an email address to create somebody's profile on your platform, to send them marketing emails, and to send them platform-related emails about deliveries and that kind of stuff. If all three of those relied on a processing condition of consent, they would have to give you 3 separate opt-ins. So they'd probably have to tick 3 boxes to say, I agree that I give my consent for you using my email address to create a profile. I give my consent for you to send me marketing emails. I give my consent for you to send me platform emails. For obvious reasons, businesses don't want to do that. So what they do is they only use consent where it's effectively the only option they have. So that might be, for example, for the marketing emails potentially, but for the platform emails and for creating the profile, they would use probably contractual performance. I'm not going to go through the rest of them, but I am going to talk about legitimate interest, because legitimate interest is a really useful processing condition, but it has some complexity attached to it that a lot of businesses are not aware of. So the idea of legitimate interest is that it's a processing condition that applies when you have a genuine and legitimate reason for processing personal data, and that can include that it's important and valuable for your business, but you have to do a risk assessment. You have to make sure that your interests are not outweighed by any harm to the individual, so the data subject's rights and interests. So legitimate interest is used very, very commonly in respect of marketing communications. So if you want to send a marketing communication, the best way of doing it is you get the consent of the data subject. So you'll see when you sign up to platforms, there'll be often a tick box that says, I agree to receive relevant and proportionate marketing communications from you. You tick that box, you're giving consent. And so consent becomes the processing condition. If a business hasn't done that or doesn't have your consent, then they may still be able to send you marketing communications in some circumstances using legitimate interest. And in the circumstance where they're using legitimate interest, what they would have to show is they'd have to show that what they are sending you is relevant to your interests, that they believe it will be of interest and use to you, and that they don't have any reason to think it will harm you. So the classic circumstance where legitimate interest is used is where you send marketing communications to your customers. So if I give an example, we're a law firm, right? You come to us and you want some help with your data protection policies. We may then send a communication to you saying, have you thought about the services that we can provide in respect of, I don't know, your T's and C's, your customer contract, or if we think you're like to raise an investment round, perhaps your investment round as well. So it is a marketing communication because we're trying to cross-sell you other services we provide, but we can use legitimate interest because we think it's relevant to you. You know, you're a startup, perhaps we've had a conversation with you where you said you're looking at your T's and C's, you're going to raise a round. So it is a little bit limited, but it can be a very useful condition. Technically, when you want to use legitimate interest, there's a three-part test that you have to apply. So firstly, is it legitimate? Second, is it a necessary thing for you to send, or is there a benefit to your business? And thirdly, is that point about the sort of balance, the benefit to the business and the risk to the data subject, is that balance about right? Is it appropriate? Now, technically, you should actually record your thinking here in a report, in a note. So you should actually do a risk assessment for use of legitimate interest. In terms of the documentation that's required, it does depend very much on your business, but the things on the screen are sort of the main documents that we tend to think about. So almost all businesses will need a privacy policy. This is a customer-facing document that appears probably on your website, and it sets out for your customers and data subjects what information, so what personal data you're going to process, what you're going to do with it, who might process it on your behalf, so sub-processors, and the rights that they have as data subjects. So that privacy policy is super important and tailored very much to your business. You may then also have a data processing agreement, and that will usually be with sub-processors or suppliers. So if I give you an example, let's imagine that we are a platform that is, I don't know, helping businesses with controlling, I don't know, payroll, let's say. So it's a payroll platform. We, as a platform, will have access to a lot of personal data about our clients' employees because we need to process the payroll. So the employer will be concerned to make sure that we're not going to do bad stuff with that personal data. So for example, we're not suddenly going to start selling those employees' personal details to third parties and they're going to get spammed with, you know, all sorts of stuff. So there will be a data processing agreement in place between us and our customer that basically says, you'll give us the information about the employees that we need to do the payroll, but we won't do anything else with it. We'll store it securely. If you ask us to delete it, we'll delete it. So those sorts of things. So data processing agreements are super important, and they're the way that businesses manage their risk and their compliance, where they are pushing personal data out to third parties. It's really important to think about personal data in the context of employees and contractors. So in your employment contracts and your contractor agreements, there will be a privacy clause that will effectively say, you employees and you contractors must comply with our business's data protection policies, and you mustn't use personal data of third parties that you have access to for your own purposes. Now, in the background, when you employ an employee or retain a contractor, you should be giving them a privacy policy. Now, that's a slightly different privacy policy to the customer-facing one. This is one that specifically relates to the personal data that you will process about that employee or contractor. So things like, referencing payroll details, potentially criminal record data. So you have an employee privacy policy that you give to them in the background. We'll talk about third country transfers in a second, but for these purposes, if you are transferring personal data to somebody in a country outside the UK, then you need to think about the legal basis that you're using to do that. Now, if you transfer to a country that has equivalency, and that basically means that the UK government has agreed that their data protection regime is the same or equivalent to ours, then you don't need to do very much. So the equivalent countries, the obvious ones are the EU is equivalent currently, and the US is equivalent to the UK regime, subject to US businesses voluntarily registering with the US regulator. But with those countries, you don't need to do very much. With countries that don't have an equivalent regime, then you need to put in place either standard contractual clauses or potentially some what are called binding corporate rules, so an agreement with a third-party business. And then the final bits of documentation, you'll have some internal policies around what you do with personal data, how you process it, and making sure that your employees know what their obligations are, and you'll have some risk assessment. So for example, around that, around legitimate interest, there'll be a risk assessment. It's worth just talking briefly about precedents. Privacy policies look often in the UK very, very similar. And so if you were to pull 5 privacy policies off 5 UK businesses, assuming they've been drafted well, they would actually look remarkably similar. Don't be fooled. There is a lot of tailoring that goes into privacy policies. So to give you an example, we collect email addresses from clients bluntly in order to send them emails, right? So we communicate with most of our clients by email. A business that is a tech platform, it collects email addresses to create user profiles and potentially to do other things, send platform emails, those sorts of things. Our privacy policy would look similar to their privacy policy, but would say slightly different things. So when using precedent, you do need to make sure that you're A, using a good precedent, but actually B, tailoring it properly. Data protection compliance is very complicated. And so, getting it right is absolutely crucial. In terms of transferring personal data outside the UK, I touched on it already in brief, but there's a couple of sort of bits to this. The first thing you need to figure out is there an adequacy decision with the country to which you're transferring personal data? So the best example I can give you would be let's imagine that you use Gmail and you perhaps use G Suite for storing documents and communicating with people. Google, primarily, most of their data is stored in the US. So you would be thinking to yourself, does the US have an equivalency regime? The answer is, from the end of last year, it does. But there's a little wrinkle to it, which is you have to check that the business to whom you are transferring the data has opted in to the regime. Google has, and therefore, when you look at Google's privacy documents, it will effectively say for users in the United Kingdom who are obviously putting data into the Gmail platform, and therefore Gmail has access to it, we are covered by the US-UK treaty, and we are opted into the regime, and therefore you don't need to go any further. However, if you were going to transfer personal data to a business that was located in, I don't know, in Kenya, Kenya doesn't have an equivalent regime, and therefore you would need to worry about how you're going to ensure that that Kenyan-based processor is going to act in a way that is compliant with UK law. So what you would be doing is you'd be doing one of two things. You would either be putting in place a data processing agreement backed up by standard contractual clauses, or you'd be putting in place binding corporate rules. So data processing agreement backed up by standard contractual clauses. Standard contractual clauses are basically clauses that get tacked on the back of a data processing agreement, and they are approved by the ICO, so the UK regulator. They're a little bit complicated, but in essence, what you have to do is you have to work out what type of transfer it is. So is it a transfer from a controller to a processor? So controllers are businesses that collect and are responsible for personal data. Processors are businesses that process personal data on the instructions of the controller. So you have a different version if it's controller to processor, processor to processor, and controller to controller. So you kind of have to do a bit of thinking on that. But then it's slightly simplistically sort of following through the guidance notes and making sure that you've ticked the right boxes. Binding corporate rules apply when you're transferring personal data between businesses generally within your own group. So if you have your UK company, you have a subsidiary in Kenya, you would use BCRs for that transfer. In essence, what they're doing is the same thing as a data processing agreement. They are regulating the relationship between the parties and ensuring that any processing in Kenya is compliant with UK rules. Data subjects have a whole bunch of rights, and you as a business have to ensure that the data subjects can exercise those rights. So I've missed out, these are the core rights that come up most often. There are a couple of other ones, but they tend to be a little bit less relevant. So the first one is the right to be informed about the collection and use of personal data. So basically, in the privacy policy for the customers, that's what you're doing. You're informing them about the personal data you collect and what you're going to do with it. They have a right to access and take a copy of their personal data. So as a business, you need to ensure that if a customer wants to get a copy of their personal data, that you have a mechanism for them to be able to do so. One of my sort of strongest bits of advice to you as new businesses, particularly if you are a tech business and you're setting up from scratch, is build in from the get-go an ability to download copies of people's personal data. Older businesses who haven't got the tech to do this, it's a really painful process if people make a data service access request. So being aware of this at the outset is super important. Number 3 is a right to request rectification of incorrect personal data. So you have, as we said earlier, an obligation to ensure that the personal data that you hold about people is correct. Data subjects have a right to require you to correct it if it isn't correct. So what you may find is people saying to you, I don't know, perhaps you're a job platform, you hold people's CVs, and you send them relevant jobs. You may have an outdated CV for somebody, and they may come to you and say, the CV you have is incorrect. Please correct it. Here is my current CV. And if they ask for that, you have to do it. People have a right to erasure, which is also called a right to be forgotten. So, it may be that if we go to the job platform example, you very happily gave your CV to this job platform 5 years ago. At that time, you were looking for a job. They were helping you get one. Now you've got a job. You're not looking anymore. And so you don't want them to continue holding your CV and holding your personal data. So you can send them a message and say, please delete all my personal data. And as a business, if you receive one of those, you have to action it and you have to delete it. Now, there are some caveats to this. So obviously, if you are required to retain personal data for whatever reason, so for example, law firms were required to retain money laundering information, you would go back to the client and say, we're deleting everything other than these data sets that we're required to retain, and here's the reason why we're retaining it. And finally, data subjects have a right to withdraw consent and eject automated decision-making. So one of the downsides of using consent as a processing condition is that people can change their mind and withdraw their consent, at which point you can't carry on doing whatever you were doing under consent. So withdrawing consent is something people can do at any point in time. Automated decision-making is essentially where a piece of technology makes a decision that has a contractual or legal effect without the input of a human being. So, this is used sometimes in sort of banking. So you apply for a loan, you're presented with a form. The form says how much do you earn, how much are your outgoings. You click submit. The software, whether it's through AI or otherwise, looks at those numbers and says, in essence, you're not rich enough to borrow from us. And the software comes back and says, sorry, we can't help. So that's automated decision making. The problem with this is that computers get stuff wrong sometimes. I'm sure you've all heard of sort of AI bias. You can find algorithms get biased in a particular direction and start excluding people when otherwise they shouldn't be. So data subjects have a right to object to their data being processed on an automated basis. So in the example I gave with the loan, you are entitled to go to that lender and say, hello, your form said no, but I would like a human being to check this, please. That's your rights as a data subject. I wanted to touch very briefly on where the law comes from, because it is a little bit complicated. So back in those heady days when we were members of the European Union, the European Union passed the General Data Protection Regulation. So that was roughly back in 2016, I think. Ironically, it was actually driven by the UK. So we had a huge part in pushing the GDPR regulation through. It became law in 2018, and we implemented it into UK law through the Data Protection Act 2018. We then left the European Union. And when we left the European Union, most EU law fell away. So we were no longer bound by the General Data Protection Regulation as EU law. And what happened is the Data Protection 2018 effectively implemented a version of the EU GDPR into UK law. And we call that UK GDPR. So we have effectively a version of the General Data Protection Regulation as English law post-Brexit. Currently, the EU version and the UK version are broadly equivalent. The good news is the new government haven't said anything that I've seen about changing that. If we were to cease to be equivalent, in my view, it would be an absolute nightmare for businesses, because you would then have to comply with the UK version. But if you were doing business in the EU, or you had data being processed in the EU by a service provider, you would also have to comply with the EU version, and you'd have to have data processing agreements and SCCs between the UK and the EU. So we don't have to do that at the moment because the regimes are equivalent, and long may it remain the case. You do, though, have to think about laws other than the UK. So EU GDPR applies to you if you are processing personal data in the EU or about residents of the EU. So most businesses in reality are bound in part by EU GDPR anyway. Other jurisdictions to be aware of: if you are processing more than a certain amount of or personal data about more than a certain amount of data subjects who are resident in California, then you need to comply with their regulation, which is called CCPA. Top of my head, I can't remember what the number is. It's quite high. I think like 50,000 data subjects. So it doesn't catch most businesses, but if you're a big tech platform, it probably will catch you at some point. Canada and Australia also have versions that are relatively equivalent to GDPR. And so if you're processing personal data in Canada or Australia or about the residents of those countries, then you will have to comply with some or all of their regulations as well. In terms of sort of thinking about which regulations apply to you, what you need to think about is, are you processing personal data in the jurisdiction? Are you transferring personal data to the jurisdiction? Or are you processing personal data about people in the jurisdiction? So those are sort of three things to think about. So if you were, for example, you're a UK business, you're processing personal data about people in the UK, in the EU, but it's all being processed by Google or AWS or someone like that who's resident in the US, then you would have to comply with all three of these regimes. So in terms of steps to compliance, in essence, it's fairly straightforward, but there's obviously a little bit of detail built into this. But the first step you need to do is figure out what personal data you're processing, who's processing on your behalf, what you do with it, where it sits in your systems. So the way we tend to do that is we tend to do what's called a data map. So it's really sort of thinking about the flows of data around your business and the people who provide services to you. Once you've understood that, for each bit of personal data that you process, you need to figure out the legal basis for it. And this was that long list we went through earlier on the slide. The key ones, as we said, tend to be legitimate interest, contractual obligation, legal obligation, and consent. So thinking about each data set, what is the legal basis for processing it? You then need to think about, are you transferring personal data outside of the UK or EU? If you are, is it going to an equivalent country, so a country with an equivalency regime? If not, then we need to think about the documentation that you want to put in place. Fourth bit on that note is documentation. So we need to have a privacy policy in place. We may need to have data processing agreements in place with our customers and our suppliers. We may need to think about SECs, binding corporate rules, where we're transferring personal data to people in countries that are not equivalent to the UK and EU. And then the final step, and by the way, the bit that I think is missed most often by startups, is we've done all of this work and we've got beautiful documentation and we totally understand what's happening with our data. We need to make sure that our team understands their obligations. The ICO published a really interesting bit of sort of guidance, if you like, so summarizing their enforcement that they've done over the last 12 months and the things that have gone wrong. 90% of the problems were actually not that people hadn't done the documentation and stuff correctly. It was that their team didn't know what the hell they were doing and weren't aware of what their obligations are and what they could and couldn't do. So making sure that you've got proper guidance for team members and that they're trained properly is absolutely vital. I think everyone who works in compliance always talks about training as being probably the most important bit. So before we go on to questions, I thought just by way of summary, it'd be worth thinking about, whether we view data protection as a problem, an irritation, or whether it's actually an opportunity. And I would say that data protection can start out feeling like a problem, but actually you should view it as an opportunity. And I think you can turn that problem into an opportunity. So the problems come, if you screw this up and you get it wrong, then you risk nasty fines and penalties from the regulator. You can be sued by data subjects, controllers, and other processors, and you can suffer a lot of reputational damage. So there's risk here if you get it wrong. What I would say to you is that getting it right is not about, or not wholly about, trying to avoid those problems. It's actually also an opportunity to be attractive to data subjects, to be a good business for customers, and actually to attract people to you in priority to your competitors. So this is really, and when you set up data protection compliance, it's an opportunity to optimize user experience. So the example I would give is, if you're a platform and you're onboarding people, so I don't know, let's imagine you're a dating app, right? We're all familiar with those. You've got an option up front. You can take all the data you're ever going to need about your user in one go when they sign up. Or you can just take their email address to get an account open for them. Once you've got the account open for them, then you can present them with their profile information and you can let the customer decide what they want to do. So do they want to upload a picture? Do they want to say their age? Do they want to say their race? I would say to you, you don't need to force them to do any of those things. People can go on dating profiles without telling you their race, without telling you how old they are. That's a user decision, not your decision. So you can give people options, but let them decide what to give you. And I think that's about optimizing user experience. If there's stuff you need, you can always build in ways of collecting that later. So if we go back to the dating website, maybe you have a free profile to start with, so you don't need people's payment information, but maybe you have some premium features where you do. And so if people want to opt into premium features, that's when you can worry about payment stuff. The second point about sort of opportunity here is actually finding ways to empower data subjects. So I gave an example earlier. I said that that one of your obligations is to allow data subjects access to their personal data and to ensure that they can get a copy of it. Most businesses, this is entirely reactive. So data subject will email you and say, please, can I have my personal data? You will then have to dig it out and send it to them. The same goes with erasure. You know, if people want to have their data deleted, they'll contact and you'll delete it. There's absolutely no reason why you can't build solutions into your software or your platform that allows people to do this themselves. So they can click a button and download all their personal data. They can click a button and they can delete maybe even specific data they don't want you to have. So back to our dating profile, maybe someone's decided they don't want you to have their race, but they're very happy to keep the profile, but they just don't want their race to be registered. So you can build in systems that enable people to control how their data is used and what data you have. You can also sometimes build in opportunities for people to monetize data. So there's some really interesting businesses out there at the moment who are saying, we will never sell your data without your consent. But if you'd like us to, we're very happy to sell your data to reputable businesses. And this gives you a cash flow that comes off the back of it. Again, people don't have to do it if they don't want to, but you're giving them optionality that makes you better than your competitors. In terms of other stuff, so we hold lots of events. I guess all of you have seen our event to be here. You can sign up to our event on our webpage, and that will also link you through to our events profile. There's lots of sort of interesting information on our insights page. I published a book a couple of years ago that covers data protection, but also all the other stuff you need to think about from the legal side as a startup. And you can download that on the link there. I think there's a discount available at the moment. I'm now going to move on to some questions. So if any of you have questions, I think chuck them in the chat, right, Ivan?
Yes, thank you so much, Mike, for that insightful presentation. I hope that everyone found it really helpful. As I mentioned earlier at the webinar, if you have any questions, feel free to share them in the chat on the right-hand side. I can see that we have a few questions. Because I'm conscious of the time, I'm just going to take a couple. And the first question is from Tilly. Are we able to send unsolicited marketing emails to prospects?
Yeah, so this is the thing we were saying about legitimate interest. So if you, assuming you don't have consent to send people an email, you'd be looking at legitimate interest. So from a UK perspective, as long as you are satisfied that what you are sending is tailored to them, you believe it will be relevant and of interest to them, then you can send them 1 to possibly 3 emails. What you can't do is start spamming them, and you also can't add them to a massive database and just start chucking them sort of regular emails. So it does have to be targeted and it does have to be limited. Just one word of warning though, some jurisdictions are much stricter than this. So Germany, for example, you basically can't do it. So unless you have consent, you can't send unsolicited emails. So you do need to think a little bit about jurisdiction and make sure that you're not falling foul of other countries' rules.
Perfect. Thank you so much. The second question that I'm going to take is from Fran. How do we deal with requests to delete data from data subjects?
Yeah, so erasure requests are probably the most common request that you'll get. So that's, I think, probably what we see most often. In essence, you respond and you figure out what data you can delete. If you need to retain data for legal obligations or whatever, then you would need to ascertain what that data is. You need to explain to the data subject what data you're going to retain and why. But otherwise, you would go back to the data subject, you confirm that you've received their request, and you would confirm that you will delete it. I think a lot of businesses panic when they get one of these requests. Most of the emails we get from clients about this are panicked. They're saying, oh my God, we've got this, or we think we're going to have a complaint. The reality is actually that a lot of people will just send a request and say, I don't want you to have my data anymore. I'm not using your service. Please delete it. And there can be nothing more to it than that. So I think try and keep a level head, figure out what data you hold and figure out what you can delete.
Perfect, thank you. And because I'm cautious of the time, I'm just going to take one final question. And if you have any additional questions, guys, you can always drop us an email at office@buckworths.com or contact us via our website at www.buckworths.com. And Mike will be happy to answer those questions. So the final question for today is from anonymous user. Do we need to give any information to employees about what we do with their personal data?
Yeah, you do. So what you should have is an employee privacy policy, which basically sets out what data you collect as part of the recruitment process and then ongoing through their employment, what you do with it when you delete it, all that kind of stuff. Ideally, that should be given to candidates when they apply, because they're giving you personal data. I think it's probably fair to say most businesses don't quite do that. They I suspect, sort of give it to employees when they join the business. If you're going to do that, you do need to make sure you're deleting CVs of candidates who haven't been employed. But yeah, best practice, you give people when they apply the or as part of the application process, you give them a copy of the privacy policy and make sure that they've received that. Yeah, so yeah, you do need to give employees copies of that policy and make sure that they've understood the way that you process personal data on their behalf.
Perfect. Thanks so much for your time, Michael, and answering the questions. As I said, if you have additional questions, feel free to contact us, drop us an email at office@buckworths.com. As Michael mentioned earlier, we organize lots of events that are relevant to startups, and our next event is on 23rd of August. It's at 11 o'clock. It's a 45 minutes presentation, and it's on legal essentials for e-commerce businesses. So if you are an e-commerce business, it will be very relevant to you, because Michael is going to cover everything from customer contracts, your obligations when it comes to returns, refunds, cancellations, VAT registration, any fees payable to third parties, and of course we are going to focus on data protection for e-commerce businesses. This again is free event to attend, 23rd of August, and Michael's book, Built on Rock, was a bestseller on Amazon. We are currently doing a special summer promotion. The book is discounted with £5 until the end of the month. I can see that we've got a few copies available at the moment, so make sure and you grab your discounted copy before they're over. And we are very active on social media. We publish lots of articles relevant to the startup world, so make sure that you visit our insights page and follow us on Facebook, Instagram, and LinkedIn for lots of additional insights. Thank you so much, and enjoy the rest of your day, guys.
Thanks very much. Bye-bye.